second panel is on the transnational scope of patent law. And we have some very distinguished panelists here to address this issue. We've got 4 panelists in alphabetical order. They are Dennis Crouch, who is currently a visiting associate professor at Boston University and has just accepted an offer to join the faculty at the University of Missouri. So congratulations. Of course, Dennis is most well known as the author of the Patently O Legal blog, the #1 patent law blog in the United States, and we're very pleased to have him here. We also have Professor Scott Kief from Washington University, who's also a visiting fellow at the Hoover Institution at Stanford, and Scott was a clerk for Giles Rich on the U.S. Court of Appeals for the Federal Circuit, so we're very pleased to have Scott here. Our third panelist needs no introduction in Silicon Valley or elsewhere, but this is Professor Mark Lemley of Stanford University, who's extremely well known and is also of counsel for Fish and Richardson.
Kecker and Van Ness.
Kecker and Van Ness, and represents a number of clients in patent law cases around the country and before the U.S. Supreme Court. He was a clerk for Judge Nelson here on the 9th Circuit in California. Our last speaker is filling in for Matthew Powers, who was not able to join us, but he sent a very able replacement, Doug Lumish, a partner at Weil, Gotshal, and Manges, who also represents a number of high-tech law clients and is a proud graduate of Santa Clara University School of Law. So we're pleased to have all 4 of you here. So I'm going to set the stage by talking about, just talking a little bit about the statutory scheme. The panel is on the transnational scope of U.S. patent law, and of course the traditional answer to that question was there is no transnational scope. Patent law applies only within the United States. There is a presumption that congressional enactments apply only in the United States unless Congress expressly says otherwise. And that presumption was applied to patent law early in patent law history. And rather than saying otherwise, Congress initially expressly said that that's exactly what they intended. So, as originally enacted in 1952, the Patent Act for infringement said, whoever without authority makes, uses, or sells any patented invention within the United States. Okay, and then we get to the Deep South case in 1972, which I'm sure most of you are familiar with, but just in case, right? In Deep South, you had the shrimp deveining machine that was the subject of a patent, and all of the components of the machine were manufactured in the U.S., but were not finally assembled in the U.S. They were shipped outside the U.S. and finally assembled outside the U.S. Some assembly required, but the final assembly was not a difficult process. It took just a few hours with some instructions. All the components were manufactured in the U.S. And the question was that making the machine in the United States or selling it in the United States? And the U.S. Supreme Court, in a divided vote, 5-4, said no, that the machine was not made until the components were finally assembled outside the United States. Congress finally got around to changing that result in 1984 when it enacted Section 271F. And it says if you supply from the United States all or a substantial portion of the components of a patented invention in such a manner as to actively induce the combination of components outside the United States in a manner that would infringe if it had occurred in the United States, then it is also infringement. Right, so this directly addresses the fact pattern in the Deep South case, and F2 is the contributory infringement equivalent of that, and we may talk about that in more detail. So that leads directly into the first case that we're going to talk about today, which is the case that's pending before the U.S. Supreme Court, the AT&T versus Microsoft case, and it's the factual companion, the Eolus Technology versus Microsoft case, which essentially raised the same fact pattern, and I've asked Mark to start us off in that discussion.
Yeah, all right. So Tyler's got the sort of background for you. It's worth knowing why don't you go back to 271 F1? It's worth knowing that the shrimp deveiner case was a particularly egregious set of facts, right? They were actually originally making shrimp deveiners in the United States. They were held liable. So then they decided, we'll make all of the parts, we'll put all of the parts in a box, and we'll put in the box a note that says, we're really sorry we can't assemble this for you, but U.S. patent law forbids us from doing so, but here are the directions that tell you how to assemble it, right? So it clearly attempted, they clearly attempted a dodge around the U.S. patent rules based on the territorial nature of those patent rules, and they got away with it, right, for at least a while. The problem is, right, patent law is territorial, and there's some good reasons patent law is territorial, which we're going to talk about. It's far from fully harmonized. So if you've got different rules about who gets a patent or whether something is eligible for a patent in different countries, it's really hard to have extraterritorial application of the laws that you enforce. But of course, commerce isn't territorial. Right? And it wasn't entirely territorial in 1972 when the Deep South packing case came around. It's definitely not territorial anymore. That puts a lot of pressure on these national differential legal systems. That pressure, I think, is especially great in the software world for reasons we're going to talk about, and that's where the EOLIS and the AT&T cases come up. So in EOLIS versus Microsoft, which is the first of these cases, EOLIS won a $521 million patent infringement verdict against Microsoft based on a particular feature that was included in Windows. It got that $521 million award not just based on sales of Windows in the United States, but based on sales of Windows worldwide. And the theory was on appeal, or the issue on appeal was the construction of this language in 271F1. 271F1, designed to reverse Deep South packing, allows the extension of liability overseas in certain limited circumstances. If you make your components in the United States and you cause them to be combined abroad, that's an act of liability. Well, what Microsoft did is it made what it called a golden master disk. Right? The golden master disk is the template. It doesn't actually run in a computer itself, but it's the template you use to make copies and burn onto CD the copies of the Windows program. It made that golden master disk in the United States. It shipped that disk abroad to Europe, and then in Europe it made a bunch of copies of the Windows program, which it sold to people in Europe. In EOLIS, the court said the golden master disk is a component of the patented invention within the language of the statute. Indeed, Judge Rader says it's not only a component, it is probably the key part of the patented invention, which is true, right? It's got all the components, effectively, of that particular patented invention. So, the court said, you can be liable for exporting that golden master disk, intending that it be combined abroad with something else to make a functional Windows program, that is, put in a computer or used to generate a copy. And the court says, yeah, it's true that software is different in some respect, but we don't think it's different in this significant respect. We're supposed to give patent protection equally to all areas of technology, and we don't see any principled reason for treating software components different than other components. But the issue in EOLIS was only the question of liability for the export of that single golden master disk. They didn't reach the issue of what the damages would be for that and so forth. In a follow-on case, AT&T versus Microsoft, the court expanded EOLIS in the same golden master situation. Microsoft, once again, has a golden master disk. Now the patent is on a computer system of which Windows is a part. And the court there held not only that exporting the golden master disk is export of a component intending that it be combined abroad and therefore subject to liability, but that all the copies made in Europe from the golden master disk and sold in Europe were liable under 271F, even though they were made and sold entirely outside the United States. Right? The court concluded that, well, this is the logical extension of EOLIS. Once we've decided the golden master disk is an act of illegal export, the copies you make from the golden master disk are also acts of illegal export. Judge Rader, who wrote the EOLIS opinion, dissented in AT&T versus Microsoft. He said, no, wait a minute. Right? It's one thing to say shipping a component abroad is illegal. It's another thing to say making an entirely new copy of the invention in Europe is an act of exporting components, right? Because there's no act of export there in the copying of the thing. Microsoft petitioned for certiorari, and the court granted cert. The case is pending. It's going to be argued next month. Most bets are that the court will reverse, I think for two basic reasons. There's a sort of statutory reason and a policy reason. Statutory reason is if you look at the language of 271F, whoever supplies or causes to be supplied in or from the United States, all or a substantial portion of the components of the invention, etc., in a manner as to actively induce the combination of such components outside the United States in a manner that would infringe, is an infringer, right? So the question is, what components are we talking about? And the reference to such components, I think, indicates that it's got to be the ones that were physically exported, not new copies made abroad that can be the basis for liability under 271F. As a policy matter, the AT&T Federal Circuit decision has a bizarre consequence. If you innovate in the United States and you export your software, your golden master disk, you will be held liable on a worldwide basis. You'll have to pay worldwide damages for any infringement of a U.S. patent. If, on the other hand, you offshore your research and development, if Microsoft had decided to produce the same golden master disk abroad, right, and then import into the United States, well, then you'd be liable only for the copies you actually physically imported into the United States under 271G, which Dennis is going to talk about in a minute. So the impact of the AT&T Microsoft decision is that it strongly encourages people to do all of their research and development, all of their innovation, outside the United States, because the rules are worse if you innovate in the United States and export than if you innovate outside the United States and import. Was that what Congress intended in passing 271F? I don't think so. Right? I don't think there was ever a time when Congress was intended to encourage offshoring, but indeed the legislative history of 271F suggests the opposite. We want to discourage the moving of some of this stuff offshore.
Comments from the panel on these cases?
Well, I guess the first comment is maybe on the policy side, Mark, is that it doesn't seem like there's anything different about software than any other than any other technology. Was Congress just completely wrong in implementing 271F? Does it encourage offshoring in all technologies?
Well, so here's the. I think it would if you made a similar interpretation, right? But of course, nobody would make the same interpretation with shrimp devainers, right? Nobody would read this statute and say, okay, if you export a shrimp devainer kit and people assemble the shrimp devainer in Europe, you're liable not only for the assembly of that shrimp devainer in Europe, but for the manufacture of entirely new shrimp devainers in Europe, right? I mean, people would say, of course, that's not right. You've made new components entirely abroad. They're not covered by 271F. What's interesting about software, and what makes this a hard policy case, I think, and this may get to, Scott's going to tell us about this, is the act of making the new copy is trivial. Right? So 271F looks like it doesn't have much teeth in software unless you interpret it to create worldwide liability because, well, yeah, okay, you're liable for the one copy of the golden master disk you shipped abroad, but it's so easy to make the copies abroad as opposed to in the United States that you won't be held liable for those copies made abroad. You know, I guess my reaction is I don't really care, in part because I believe in the territoriality principle, at least unless and until we can harmonize patent laws. But software is different in that respect. It's also different in one other respect, and then I'll let Scott talk. The petitioners in the case took this opportunity to throw some not too veiled challenges at the patentability of software itself. Right, so there are two issues presented in the case, one of which is the statutory interpretation, does damages reach this foreign copying conduct, but another issue that Microsoft has tried to present is this the kind of thing that you can really be a component at all? And if the court takes that larger route, it says software can't be a component because it's ones and zeros, then I think we're going to have a relatively significant decision out of the court.
Yeah, I think that's exactly the right issue. When you say there's no difference between software and any other type of component, I think that assumes a premise that may not be true. The Supreme Court could be very sloppy in its decision making and apply the component to the information. If the component is the information, then every time somebody in the United States has an idea, just the idea, a recipe, for example, and ships it overseas, communicates it on the phone, that idea could be found to be an infringement. The practice of that idea in a foreign country by another company, maybe an affiliate, maybe not, could be an infringement of a United States patent, despite the fact that the only thing that happened in America was the flash of genius, as it were. So it may be true if the software is really, if the software in AT&T, I should say, is really the structural disk with the dimples on it that create the ones and zeros, well, maybe there is no difference. But if it's the information, I think there could be a very serious difference.
Well, so there are other binding elements of the test. So, intent is part of the inducement analysis, and part of the analysis, at least for an F2 case, is going to be that intent. Right. And remember, there are safe harbors built into 271C that are essentially mimicked in 271F1, which are the staple articles of commerce suitable for non-infringing use safe harbors. So if ideas are capable of substantial non-infringing use and there is no intent, then you're not a B or C case if it had been in the U.S. You wouldn't be an F1 or F2 case if overseas. So it may be another way to slice all of this stuff is to ask, biotech and high-tech are going to be two industries where it's going to be really, really easy to avoid infringement liability, because you can just give a copy overseas and then know that all overseas subsequent copies will be non-infringing. I guess depends on which side of the patent coin you are, whether that's a wonderful thing or a bad thing. So some of this stuff then starts to boil down to, overall, what are your views about whether patents on average help or hurt?
Can I just amend that? I mean, I think Scott's onto something important here, but I don't think it's exactly right, or it's incomplete, I guess would be fair to say. With software and DNA, with these technologies that can easily be replicated or even automatically replicate themselves in naturally occurring circumstances, what's right to say is that it is, you get polar extremes. You either get trivially easy to evade by going offshore, or you get worldwide liability no matter where you are because we reach offshore. What's hard to do is to replicate what we do in the physical world, which is this kind of territorial intermediate rule, where you're liable for the U.S. and only the U.S., and if you want to get liability in Europe, go get a patent in Europe.
Right. And you evade what? You're evading a U.S. patent, but there's still foreign patents you may have to face.
Well, right. And what's interesting about the software issue, and some people filed amicus briefs in AT&T Microsoft that said basically, don't extend liability here because many other countries don't grant software patents, and they should be free to do that.
So another way to cut at this, though, is to say, what is this presumption of territoriality? Is that a normative presumption? Like, we all basically think it's good for the U.S. law to only reach U.S.? Or is that the type of thing that's just kind of a page in the playbook that every defendant uses when she develops her strategy to go out and reach as far as she can to infringe, right? Remember those old cartoons you used to see where the guy stands in front of the guard dog, and he then measures the length of chain that's holding the guard dog back and stands 1 inch longer than that chain and taunts the guard dog. There's a presumption that the chain is going to hold the guard dog back, but that's the defendant's presumption that, hey, I can get away with it if I just stand 1 inch further away. So give an extra inch on the chain. Release the chain. We choose to do that in the U.S. all the time. We have chosen in the U.S. to make our laws reach acts that we think are bad. Now, we do that. We do that for all sorts of torts. Why can't we do that for IP, and why shouldn't we do that for IP?
So let me offer two thoughts here, right? Scott's right to say that the territoriality presumption in patent law is not the presumption we have in various other areas of law, in antitrust law, for example. We're happy to reach conduct that occurs entirely between Japanese companies. Now, many other areas of law, it is the presumption, right? We make choices, we make policy choices. Two things to think about. One is, whose policy choice is it? I think, given the language of the statute, Congress pretty clearly didn't make the choice for unrestricted worldwide liability, though Scott has an argument that says we could. The second policy concern I have is, because we don't have a harmonized patent system, you're going to get some awfully anomalous results. We grant a patent to the first to invent. Everyone else in the world grants a patent to first to file. That means two different people can and sometimes do end up with patents on the same invention. So if my patent as the first to invent has worldwide rights, what happens to the guy who is sitting in Europe and is actually the patent owner in Europe on the same invention, right? He's liable for infringing my patent on an extraterritorial application. Ideally, so in an ideal world, I think we would have extraterritorial application, but we'd have it in a harmonized universe. But of course, I believe in world peace too.
And Mark, almost all the products you're talking about already have multiple patents covering them. And so we're already dealing with that, you know.
And also, I mean, there's world peace, but then there's also world domination. And I'm perfectly happy to recognize that we don't want to be in the business of dominating the world. They can set their patent laws and their tax laws and their environmental laws and their FDA laws however they like. And by the way, we've long been comfortable with all of those, quote, anomalies. There are lots of drugs that you can buy here that you can't buy overseas, and there are lots of drugs you can buy overseas that you can't buy here because we make a different judgment call on what's safe and effective than other places. We make a different judgment call about what's environmentally responsible than other places. And depending on how your politics are on each one of those issues, you'll probably disagree with yourself if you compare almost any two of those issues. Those anomalies are all over the law. Why do we suddenly have to have uniformity for IP when we don't have it almost anywhere else?
We framed the discussion so far in sort of U.S. companies going outward, but I think as the United States has become a knowledge-based economy, you have to think about foreign countries coming to us, or companies, I should say, from foreign countries coming to us to do some of the knowledge work. Why would you, as a foreign country, hire an R&D group in the United States to do your thinking for you on some design work or engineering work you're going to have, if that might subject you now to your European or Japanese sales, to subject those to American patents? You're not going to do it. So on the policy side, I think you have to look at it from both sides of the border.
There will be both positive and negative effects, right? I mean, we can always put the cloak of goodness and truth and justice over our defendant, and we can always put the cloak of goodness and truth and justice over our plaintiff. But I don't know why, in a sense, any of this stuff matters, right? I mean, don't get me wrong. I like Microsoft. They're nice folks. They've supported my work. Actually, in the past, AT&T hasn't supported my work. So, you know, maybe AT&T ought to take out their checkbook and, you know, I'd fight harder. No, I mean...
this is the Bush doctrine.
The bottom line is not to be pro or anti-Microsoft or pro or anti-AT&T. The bottom line is to say we made a decision that we saw it was going to be really easy to avoid infringement in the Deep South case. And so we wrote statutes designed to reel into the net all of these acts that were occurring where they were non-infringing simply because the direct infringement happened to be outside of the U.S. Now, even if you know, Mark, I guess I'd say, even if you win this case, right, how do you win it? Do you win it on a statutory construction point, in which case, then why don't we just go back to Congress and rewrite the statute to cast the net a little wider? So on the kind of policy point, or on the normative point, do we have the power to do this? I don't think anyone's made the argument that that Congress doesn't have the constitutional power to pass a statute.
No, that's right. I think they haven't passed the statute, and it's a good idea that they haven't passed the statute. And so this is, I think, a lot of the reasons why it's a good idea come when you sort of start to move, as Doug suggested we should, from components to information. So maybe that's the sort of logical transition.
Well, these panelists make it so easy for me, but we do have a lot of other cases to get to. So let's try moving on, and let me ask Doug to introduce the NTP versus Research in Motion, because these are not the only cases. These are not the only cases. Which one?
I thought we were going to Dennis and Pellegrini.
Oh, okay. We can go to Pellegrini first.
I'm so ready to go.
Pellegrini involves a different fact pattern involving 271.
Right. So Pellegrini actually is the precursor to the Microsoft and Aeolus case, but not by much. It came out, I believe, in 2004, and it's a little bit of a strange decision, I think, in part because Pellegrini was pro se, but it still came out as a precedential Federal Circuit opinion, and it involved a patent covering a brushless motor, so a little electric motor that worked in a certain way. And Analog Devices was accused of making and selling this invention. Analog Devices is located in Boston, but their manufacturing plant was abroad, and they were also selling abroad. And so none of the physical, I like to think of them, none of the molecules of the invention of the product that was being sold ever came into the U.S. What did come out of the U.S. were instructions. There were a lot of input in terms of sales. There were also the engineering specs that told exactly how these would be made. And interestingly, Analog also put in all its products a notice that all of their products were made in the USA, when in fact they weren't. At the Federal Circuit, Pellegrini argued that shipping out, two arguments. One of them was that this notice was, that Analog should be essentially stopped from arguing that they didn't export it because they put in this notice, and the Federal Circuit dismissed that. But more to our point today, Pellegrini argued that the engineering designs that told exactly how to make the product should be deemed a component as well. And the Federal Circuit dismissed that and gave pretty good language, saying that 271F applies only when components are physically present in the U.S. and then either sold or exported. And then they go on that supplying under 271F clearly refers to physical supply of components, not simply to the supply of instructions or corporate oversights. So in this precursor to the Microsoft cases, the Federal Circuit, it looked like they came down pretty hard in terms of saying we're talking about physical products and not something like software. And there's kind of a companion case to Pellegrini that involves 271G. And 271F involves export of components, and 271G is talking about importation. And 271G specifically is about importation of products made by patented processes. So if you have a patented process, for example, in the case of Bayer v. Housey, there was a patented process of screening for a drug. And I actually haven't read the claim, but I assume that the process was something like inspect a number of different drugs and see which one has the best properties, and discover that the one with the best properties is your drug. And so we've got a screening method, and under 271G, importation of a product made by a patented process can be infringement. But in that case, the court said, no, when Congress implemented this, they intended that products made means that they're physical articles that have been manufactured. And in Housie, the result was that we came up with a particular drug. We came up with an answer. We came up with information about what drug was infringing. And the court said that is just information. And information is not a physical product, and so information alone cannot be an infringing product. And I think that these two cases kind of set the boundaries of how 271F can be interpreted, and it's a little hard to tie them into or to align them with the Microsoft case. But I think with the Pellegrini case in particular, although Pellegrini talks about physical supply of components, I think the real distinction that at least the proponents of expanding 271F talk about is that, you know, the difference in Pellegrini is that the invention was not actually being exported. It was just plans for the invention. While in the Microsoft case, the actual software that was, for all intents and purposes, the infringing software was being exported.
And here we come to the really fun part about software, right? Pellegrini and Bayer v. Housie, I think, set the end game for the Microsoft case. If Microsoft loses, right, if the court decides if you ship the golden master disk abroad, that's a physical movement of a component, and now you're liable worldwide, what's Microsoft going to do? They're going to read Pellegrini, and they're going to say, fine. This is just software. We'll just move the information, right? Maybe we'll email the source code to Europe. Is that the movement of the actual invention, right? It's clearly not a movement of physical components, but it is the whole invention. Or maybe we write it down and we physically mail on a piece of paper the schematics, right, or the printed source code, and then we re-input it in Europe. And so I think the problem is, I mean, if you believe Scott's view of the world, right, that this is the problem is just as bad if you're exporting information as if you're exporting a software component that can readily be copied, right? And so either Pellegrini and Bayer have to give. Either we got to say shipping information back and forth is an act of patent infringement, or we got to draw the line somewhere else. But it seems odd to draw the line to say, well, if you've instantiated your software in some physical form, you're out of luck. But if you keep it in some intangible form, you're okay.
That question is potentially going to be decided in AT&T, because the AT&T Federal Circuit panel distinguished itself from Pellegrini and said, unlike Pellegrini, where you only sent, or where only instructions were sent, here a tangible thing, or what Judge Lurie calls in a dissent, the equivalent of a tangible thing was actually sent. So that debate may be decided. It may put to rest. It gives me some optimism anyway for this concern about whether 271F components will be applied to just ideas.
Although again, I mean, in case it wasn't clear, although I'm sure Mark will disagree with this more, I think it would be fine to not have the tangible requirement. I've never understood that. I mean, I think that's why, State Street makes sense. I think that's why, I've never understood this kind of fetish we have for stuff we can touch. I think that the reality is a business today in this country is a business of helping folks think through stuff better. And if that's what our economy is good at, and we can help folks think through stuff better, and we can do it in ways that are new and non-obvious, and we can write them down in ways that are described and enabled, then we ought to get patent protection, and that patent protection ought to be meaningful, not totally irrelevant simply because you can do it overseas.
Let's just think briefly about what it would mean to say that the idea itself, without any physical manifestation, right, exporting that idea is an act of liability. I wouldn't pick up the phone if I were a Microsoft employee and call anybody in Europe, right, to communicate that idea. Because, well, heck, if emailing it is illegal, probably calling and discussing the idea, describing it is illegal. I wonder if you can get on a plane to Europe, right, carrying the idea in your head, right? There's a reason we actually limit patents not to these sort of purely abstract ideas, but to some sort of physical, tangible implementation. Software, there's no question, software puts pressure on that definition because of its malleability. But I think there's got to be a line somewhere short of the idea itself can move.
Not to lapse too much into a State Street debate, but State Street says the exact opposite, and it does so on purpose. I mean, that was a...
we blame you.
So disclaimer, it's a court decision authored by a judge for whom I happened to work at the time. But I was a law clerk, and you know, it ain't my decision, and you know, I mean, but I do think it's right.
When I was a law clerk, we used to joke about printing up T-shirts that said, "There's only so much we can do." Okay. Well, there's a lot of pressure on 271F these days, and now we'll get to Doug. Sorry to yank your chain back there just a couple minutes ago, but Doug's got a couple of cases to talk about, and let's start with the BlackBerry case.
Right, so the NTP versus Research in Motion in case it falls in timing right after Aeolus and AT&T and right before Union Carbide, which is the second case I'll talk about. And it's famous or infamous or nefarious, depending on your viewpoint, for being the first 271F case applied to a method claim. There were method claims in some of these other cases, but the holdings were all limited to the apparatus claims. So I'm sorry, I'm confusing myself with Union Carbide. We get back to NTP. So NTP comes after Aeolus and AT&T, comes before Union Carbide, and I think you can see it as sort of a simultaneous contraction and expansion of the extraterritorial reach of 271 by the Federal Circuit. The expansion really shows itself in its treatment of 271A and a sharp divide that's drawn between method and apparatus claims. So 271A requires that the invention be used, if you have that up there, within the United States. You can see, is it?
Yeah, that's got the post Deep South amendments there. So
okay,
makes uses offers to sell or sells an invention
within the United States. You can see it in the middle, not in red, right there. And the case, I think everybody's familiar with it. It's the BlackBerry case. There was an undisputed fact that's an important thing to understand for this discussion, which is all of the BlackBerry emails that were received by the handheld units in the United States were routed through Canada. And more importantly, the patentee, NTP, was accusing that Canadian relay as being the thing that practiced one of the limitations of its claims, both on the apparatus and the method side. So there was no dispute that for NTP to win, it had to show that it had to get the court to accept that practicing the method or using the system could include this foreign component, this Canadian component. On the apparatus side, let's start with the method side because it's easier. The Federal Circuit said in no uncertain terms, no, you cannot have the use of a method under 271A where part of the method is practiced outside the United States. Every step of the method has to be practiced within the United States to fall within 271A. And so that infringement theory was discarded. On the apparatus side, however, it reached relatively deeply into its toolkit and pulled out a 30-year-old Court of Claims case called DECA to say, in DECA, it was a triangulation of radio signals process that was being accused of infringement. And one of the three triangulation points was in Norway. And the Court of Claims said that that's still a use within the United States of this system, the patented system, because the control of the system and the beneficial use of the system are all in the United States. And the court in NTP basically applied that same reasoning and said the control of the system is this guy. It's the beneficial use and the control. The emails being sent from and received to your BlackBerry, which half of you are probably using instead of listening to me right now. And the beneficial use is clear to the user of the BlackBerry. So they found infringement under 271A. Going to F, though, they didn't even look at the apparatus claims. They said because apparatus claims were found to infringe under the use of the BlackBerry system under A, we're just going to look at the method claims. And the holding is very interesting, I think, for two things. One is the language is relatively narrow, and the Union Carbide case will grasp onto that strongly, I think, to try and distinguish it. But there's some very strong language about why the holding was reached. So the holding is essentially when you sell a BlackBerry into the United States, you're not then supplying a component that's combined outside of the United States to be an infringement under 271F, which is required. So on that holding, I think it was more, you can read it to be more based on whether there's something being shipped out of the United States. But in reaching that conclusion, the Federal Circuit said in very strong language, it's difficult to conceive of how somebody could take a component of a method claim, which the Federal Circuit in that case, NTP, clearly saw to be the step taken in the process. Not a thing used to do the step, but the step itself. How could you supply a step, combine a step from the United States with something outside, and practice a method claim under 271F? So it appeared that there was potentially a constriction, or at least a slowing in the slope here of extraterritorial expansion. But as the Union Carbide case really shows, that's more of a tap on the brakes. Union Carbide comes out just 2 months later, and it's a case in which the defendant, Shell Oil, was selling what are called catalysts. I'm no chemist, but essentially a chemical used to help form something called ethylene oxide that you then use to make films, resins, polymers, stuff like that. And it was just it was a process. The one claim that went on appeal was a process, unambiguously a method claim that required you to make ethylene oxide and to use the catalyst to do it. Shell had been found to infringe in the United States for its own use of its own catalyst to develop ethylene oxide. But the district court didn't allow in the damages computation the exportation, this revenues and sales that had gotten by exporting these catalysts. The Federal Circuit reversed that and said that was an error. And it did that by revisiting really what the component is of a method claim. It said 271F definitely does apply to all inventions of all kinds, as it had said broadly in Aeolus, and that the component of the invention, the catalyst here, could be the thing used to practice the step. So unlike NTP, where it's the step itself is the component, which is hard to envision could be supplied, a thing used to practice a step under Union Carbide is enough to get you to an infringement under 271F. Now, the case was requested to go en banc, and it was denied. Judge Lurie has a very interesting dissent in which he goes back to NTP and says, no, that's really the component of a method claim. A step is really the component of a method claim, and we got that right the first time. We should revisit this conflict in the laws. And he also points back to a 91 case, I think it's 91, the Standard Havens case, in which the Federal Circuit kind of offhandedly, but I think clearly said the 271F statute's inapplicable to method claims. So there's a very clear conflict in Federal Circuit precedent. If you look at Standard Havens and NTP saying you can't have the practice of a step of a method by sending an apparatus overseas, compared to Union Carbide, which says exactly the opposite. By sending a catalyst overseas to be used in a method, you do end up with a practice or a 271F infringement.
Comments from the panel on those two cases? Okay, everyone's happy with those?
No. but Doug's explained why we should be unhappy with them.
I think maybe one more comment on it is I think to go back to the idea of whether the exportation of an idea, which I find very, very scary, and I know my clients do, is a real thing to be worried about. If the Supreme Court in the AT&T case is relatively broad in its language, and if it treats the component of an invention under 271F as the information, the idea, well, then under that, in AT&T it's an apparatus claim. But under the Union Carbide precedent in the Federal Circuit, you've got, a method claim. So now if the Supreme Court says an idea and a method claim is all you need, we're back to this concern I have of somebody comes up with an idea in the United States, tells somebody in Europe, and now they're infringing a patent when the product is made, shipped, sold, and done entirely overseas. Gives me a little hope on that, a little hope, a glimmer of optimism, is all of these cases involve the shipment of a thing. In Shell, even though it's a method claim, it's a shipment of a tangible thing outside of the United States. In the AT&T and Aeolus case, it's a shipment of a disk. And as I mentioned before, the Pellegrini case, the Federal Circuit still seems to be holding by the fact that shipment of instructions or transmission of instructions isn't enough.
So the one case that isn't a shipment of a thing, is the BlackBerry case. I'm sorry? You're right there. Of the ones that Doug's talking about, the BlackBerry case, right, what's interesting is the court's focus on this locus of infringement idea. right? Where's the kind of central, if we have to pick a country where infringement is going on, where is it? There's some sense to that idea in a context in which the invention does, in fact, occur in part in various different countries. The question is, how are you going to decide where the locus of infringement is, right? So the court says control and beneficial use of the system. And the court clearly thinks that you pick up your BlackBerry, you send an email, the control and the beneficial use of the system occurs in each individual end user's hands. I think there's a plausible argument that that's not right? That the control and beneficial use of the system is where the central relay server is, right? Where, in fact, the RIM people run the program, because you take that away, and you can send emails all you want, but nothing's going to happen, right? I mean, these are the nodes, right? I would think, for example, in a client-server system, that it's the server, the central server, not the clients that are the control and beneficial use of the system. But what's interesting is that either way, we've got this and all you got are this sort of possibilities of huge liability or no liability. If we say the control or beneficial use of the system is the server in a client-server arrangement, well, it's pretty easy to put that server somewhere that you don't have a patent. Right? If, on the other hand, you say control and beneficial use of the system is where each and every client exists, which is, I think, what the court at least implies in the NTP case, then it's impossible to avoid effectively worldwide liability. Right? I mean, I can say if I set up a system and there's a patent somewhere in the world that covers the BlackBerry, I'm going to end up being liable for doing that because somebody's going to go into that country carrying a BlackBerry, and now I'm infringing because they did so. So again, just as with software, right, there's a real problem trying to find a measured medium for liability, right, that's not either global liability or trivially easy to evade liability.
So I'm just curious, maybe to run a thought experiment. A lot of these cases that we've been talking about so far, I think, are boil down to the following debate. You either think that 271F and F1 and 2 were kind of written to basically allow people to sue in cases where it'd be a good 271A, B, or C case, but for the geographic location of some stuff. That would be one view of F. And another view of F is, no, F didn't say that. F tries to carve out something less than that, and then you get a battle over what exactly the words in 271F mean. So the thought experiment I guess I'd offer is, what if we rewrote F to expressly make it the first case?
No, the current revisions of the Patent Act don't have F at all, so fine with me.
Well, but it's right. But so then I think you really are in a situation of worldwide liability, right? I mean, so
sure.
So suppose that I mean, if you got rid of the national boundaries, right? So you could violate 271A by doing something entirely outside the United States without doing anything in the United States.
And then what would the limit be on the lawsuit? Well, I mean, the limit on the lawsuit would be, is that person in the U.S.? Do they have assets in the U.S.? Are they doing business in the U.S.? So it's not as though we're going to, actually reach outside. What we're going to do is reach inside to the extent
but
people inside.
We've demonstrated over and over again on the internet that doesn't work, right? Find every defendant in a peer-to-peer network, and you'll find somebody who is not in the United States, who is in a country that has no relationship with the United States. Maybe a 15-year-old in Norway, maybe somebody a company in Nevis, a company in Vanuatu, and sure enough, they all end up in front of the United States courts. And the reverse is true, right? Go to Europe, where they decide that internet intermediaries and internet service providers should be liable whenever anybody does anything that offends anyone on the internet, and they're happy to hold folks in California liable for having hosted something that somebody on France put that somebody else in France saw. And So there's not, I mean, I think there is no, you can't just say, well, we won't get worldwide liability. You can say worldwide liability is okay, U.S. law should reach out and kind of take over the patent systems of the rest of the world. I don't want to say that.
We'll get it to the extent we get it in those other settings.
I don't think that's what the legislature had in mind. In the Bayer case, they talk about 102F and 102G together. They talk about the purpose of those amendments being to prevent manufacturing outside of the United States, not expanding the reach of 271 to other countries or activities in other countries outside of manufacturing.
Okay, well, we've got a couple more cases here to get to. One is for a little older, but I think still raises some interesting issues about extraterritoriality. It's Rotec versus Mitsubishi, and it involves the post-Deep South revisions to 271, which includes offers to sell within the United States.
Yeah, so both Rotec and then MEMC are two cases where you have business activities, people engaging in conversations, and those conversations and the email swapping and the document drafting, some of that occurs in the U.S. and some of that occurs overseas. And then there's stuff that looks like a candidate for patent infringement that follows. And then the question becomes, okay, what cause of action could there be? And the two basic arguments are going to be either, one, under the new offer for sale provision in 271A, have those conversations or email exchanges or purchase order exchanges that occurred within the U.S. offers for sale? And if not, what about when stuff does get supplied overseas? How much supplying do you have to do? That gets back to the conversations we were having already. And lastly, does an offer to supply trigger the 271F supplying language? And so these last two cases, MEMC and Rotec, deal with, in a sense, these questions about what is an offer. The cases are highly fact-dependent. The patentee loses in both cases, and just to show I'm a fair guy who ain't out to make sure that every patentee wins, I want to be clear in saying I actually have no problem with these cases. I think that it's fine for patentees to lose, and these are cases where patentees lose. They lose because what the Federal Circuit says it's going to look to on this question of offer for sale is what you and I would think of as the Barbary version of contract law offers, right? And so you go back to your first year of law school, or you go back to your bar review, and you remember what's going to make an offer. And what's going to make an offer is a manifestation of intent to be bound with terms identified in the communication, material terms of the putative contract, targeting a person who could say, I accept, in the contract sense, to that offer in a way that would then make that a contract. So what are some important things to look at? Does the person who writes the document put in the document important terms like quantity and price? Is it addressed to somebody who could say, I accept, in response to it? And in these cases, what really boils down, when you look at the facts, you've got exchanges of documents, but they're not sent to targeted individuals, people who could say, I accept. Or they're too vague. They don't have the material terms. They don't have price, or they don't have quantity. So they're not the type of thing that in a contract law sense, I could say, I accept and bind you to a contract. So I think that in a sense, these cases are relatively uninteresting or unsurprising in the narrow reading of the cases because they just apply contract law that we would expect to get to a result that says these communications are not offers, and if they're not offers, they don't trigger the 271A offer for sale provision. I think that the more difficult and interesting issues in these cases have to do with debates among the authoring judges that appear in one case a concurring opinion about how much further all of these things would go. And so there is a debate in the Rotec case between the majority opinion and the concurring opinion by Judge Newman about whether offering to supply would be actionable under 271F, just like supplying would be actionable. And the court doesn't seem to reach that question in the case. The majority opinion suggests that it reaches it, and the concurring opinion is a concurring opinion because Judge Newman says, actually, you didn't need to reach that issue. The underlying liability question was mooted because of some other facts. So there are potentially interesting debates raised by these cases, but not for their narrow holdings.
But I want to focus on Judge Newman's concurrence because she raises the question, the phrase offer to sell within the United States. Does that mean an offer within the United States, or does it mean a sale within the United States? That is, offer to sell within the United States. Because in the case, the alleged offer took place in the United States, even though they found factually it wasn't an offer. The alleged offer took place in the United States for a sale of patented technology to be used in China. Right? So, how should we construe 271A? Is it an offer for something that will be sold in the United States if accepted, or is it merely an offer in the United States that occurs for a sale anywhere in the world?
And so, you can go either way on this. My view is that actually the right way to read the statutory language is that it's the offer for sale that has to occur in the United States and not the actual sale. So that is a form of extraterritoriality, right? But that provision was added as part of our TRIPS agreement. If you look at the kind of parallel construction, right, everything else is the making, the using, the selling, the importing, all these things are things that must occur within the United States. The phrase offer for sale, it would be odd to construe as sort of separate in that respect. Though I can see you can make the argument in both directions, right?
Particularly in light of 271I, where the sale must occur within the patented term.
Right.
Right, and she said, similarly, the sale must also occur in the United States.
Right, though,
you could draw a negative.
I was going to say, well, I'm not sure you can go either way with that, right? I mean, so we got a separate section that says specifically must have this attribute, but doesn't say you must have some other attribute. Depends on how you construe that. The other interesting thing to note, by the way, in this area, and MEMC touches on this, is 271B, inducement. Right, so in the United States, from the United States, within the United States is all over 271, but it doesn't show up anywhere in 271B. And so it seems pretty clear that an act of inducement of patent infringement can be one that occurs anywhere in the world, as long as the thing induced, the infringement that is induced, occurs within the United States. Right? As long as it is a U.S. patent that is infringed by somebody else, if you're in Japan and you call up and order the production of this thing within the United States, or you encourage someone to make an infringing material, that entirely foreign conduct that produces an act of infringement, I think, is an act that violates 271B. So there's a kind of extraterritoriality wrinkle just written into the way the statute has been created.
Any other comments before our final case? We're all set. Okay, so for our last case, it has to do with the jurisdiction of the United States courts to hear claims of patent infringement that may have arisen elsewhere. It's Voda versus Cordis. The district court opinion on this issue is not published, but an appeal is currently pending before the Federal Circuit and has been for the last 12 months. It was literally argued in January of 2005, January 2006, and we're still waiting for the opinion 12 months later. But Mark, you want to tell us about Voda?
Sure. So this is the one, if you're a patent practitioner, this is the one that could change your life, right? I mean, the various other things that we're talking about come up in particular cases. In Voda versus Cordis, Voda sued Cordis for infringement of a medical device patent. And he then sought leave to amend the complaint to add charges of infringement of his Canadian and European patents in the United States court under the doctrine of supplemental jurisdiction. Right? And the doctrine of supplemental jurisdiction in various other areas of law says if a federal court's got subject matter jurisdiction over a case and there are parallel disputes between the same parties such that it would be more convenient to resolve because they're going to have the same facts, you can bring those disputes into this court even though you wouldn't be able to bring them independently in this court. So you can basically attach them to the existing patent case over which they had supplemental jurisdiction. District Court granted the motion, said, yeah, you've got parallel patents, they all came out of the same application. I don't see any reason not to hear claims for infringement of the Canadian and European patents along with the US patent, because it's much more convenient from a global judicial perspective than having 3 separate court proceedings, or 29 separate court proceedings, I guess, because you got to do national enforcement in Europe. The court has appealed. The court granted leave for interlocutory appeal. So this decision was in August of 2004. Court has appealed. They did the briefing. The case was argued by the Federal Circuit, and we're waiting. And we're still waiting. My guess is that we're waiting because the court is actually having an internal discussion en banc about what to do about this issue. It's a sign of how long we have waited that 6 months ago, the court, while it granted the interlocutory appeal, didn't stick around to wait. They've actually had a trial, found infringement, and determined liability. They denied injunctive relief after eBay, granted damages. That decision is now on appeal, and I suppose at some point it may lap the original interlocutory appeal decision. But this is, I think, an enormously important issue, right? Because it makes some sense as an abstract matter to say, if you've got patent applications that all come from the same basic source, so the prior art is going to be the same or mostly the same, or so the infringement issues are going to be similar, maybe we should all hear them in one forum. But boy, is it going to change your life if it starts to happen as a regular basis, right? Because now you've got to learn foreign patent law. My guess is that there's going to be a real constraint on this, which is supplemental jurisdiction is discretionary with the district court judges, right? And there are going to be a limited number of district court judges who want to decide not just patent cases in the United States, but foreign cases involving foreign patent law as well. So my guess is it will remain the exception rather than the rule, even if the Federal Circuit allows it. But it is something that is potentially quite significant change.
So just a quick comment. To the extent judges like being invited to give talks in Europe, that may cut the opposite. And you know, it is. I mean, this is not a new issue in the sense that we have seen in IP, in commercial litigation generally, this difficult question of federal-state supplemental jurisdiction. And we've seen on the other side of the coin this difficult question of, you know, Dutch courts enjoining shutting down factories in Kansas City, right? I mean, you see versions of this. So this is not fundamentally new, although I very much agree with Mark that this is could be exciting for everybody. But again, I mean, at least as somebody who used to try a lot of patent cases, I'd welcome a trip to Europe to do that discovery. That would be fine with me. So maybe this is good news.
We do have a limitation in the active state doctrine. Any comments on how that might play out? Okay, the active state doctrine says, as a general matter, the courts of one nation will not adjudge the governmental actions of another nation. And granting a patent has always been seen to fall within the active state doctrine, so that at least the issues of validity of the patent should not be judged outside the courts of that nation. Is that going to be a limitation on what we do in VOTA?
I suspect what they would be able to do is say that they, again, in these cases of jurisdiction, they're not choice of law cases. So it's not like we're saying we're going to adjudicate the French patent under U.S. versions of patent law. We're going to do it under what we understand the French versions of patent law to be. And so in that sense, we're actually giving effect to the foreign national courts and legislatures' decisions. We're just their arm.
Giving effect to our understanding of their...
I recognize that.
But of course, we do that in lots of other contexts, right? I mean, there are all sorts of circumstances in which we interpret foreign law. We got whole rules of choice of law and least in some circumstances, require that differ from choice of forum, right? So they require one court to hear the case, but to apply the law of another jurisdiction.
Well, enforce foreign contracts in the U.S.
But applying foreign law to determine whether a contract is valid is different from saying that a foreign patent office got it wrong. And if you're unable to judge the validity of the patent or the inequitable conduct, for example, to the extent that theory applies to other foreign courts, then what's the point? Yeah. You're going to have an infringement verdict or not, but you're not going to be able to. I can't see a district court judge granting an injunction or even damages without first having the validity issues decided. So you're just bifurcating the proceeding if that's the
right. In which case, it doesn't save any resources. It's an interesting problem. Two things I guess I would suggest. One is it's a problem that's heightened in those foreign systems that do not actually give to courts the adjudication of patent validity, right? So in Germany, for example, where where infringement is all that goes to court, and if you want to challenge the validity, you go up through the patent office technical appeal. The second thing is, just kind of speculating here, I wonder whether the active state doctrine would be implicated if the rule was not your patent is invalid, but your patent is invalid as to this party. Right, so that having made the affirmative choice to bring the patent, right, voter says I want to bring my Canadian patent, my European patent before this court. It might be that that consistent with the active state doctrine, the court could make an adjudication that didn't bind VOTA vis-a-vis everyone else. That didn't say we're ruling this wrong, but that said you having chosen to bring this into this court lose, and so you can't enforce this patent against Cordis anywhere in the world.
And maybe even against anyone else in the U.S. I mean, I would be comfortable taking that case for another defendant asserting non-mutual.
But I should be clear that we're well outside my area of expertise, and so consult a foreign lawyer, an international lawyer.
Okay, well, we do have some time for questions with our distinguished panel, so let's start it up. Let's start here first.
This is a question for Scott.
Can you speak up?
Yeah, sure. This is a question for Scott. I noticed that last year actually was the first year in history that there were more IPOs in exchanges abroad than there were in the United States. The securities lawyers were really upset about this. The consensus seems to be that it's because there's so many regulations in the United States now, and like the Sarbanes-Oxley. So I'm wondering, maybe we could take a page from that and learn, like, well, if we make our curriculum as lawyers, I mean, there are now competing forums that didn't exist in 1974 that people are taking advantage of.
So I think that's a wonderful question, and I'm very sensitive to those issues. And I do think changing hats to the other stuff that I do, which is commercial and securities and antitrust, and that actually we do have kind of a little too. I do think Sarbanes-Oxley is a problem, and I do think that is a reason we're seeing a lot of exchange activity overseas. So I totally recognize that concern. I think that there is a material difference between the problems that Sarbanes-Oxley imposes and the problems that more patent infringement imposes. The worst patent infringement would get by making it extraterritorial is, I think, just nowhere nearly as bad as Sarbanes-Oxley for the following reason. The nature of the scope of liability is far more predictable in the patent game. The nature of the scope of liability in the Sarbanes-Oxley game is so uncertain and so extensive that you're not talking about kind of, okay, my business has to pay more money to somebody. What you're talking about is, personal liability, the perp walk. I mean, those are kinds of things that, people just really are afraid to deal with. Businesses come and go. They have to pay big judgments. That's okay. They declare bankruptcy.
Well, but Scott, the second thing you said, which is that the stakes are higher, I agree with. The first thing you said, which is that it's less clear, is nonsense, right? I defy anybody to take any patent and make an absolute prediction that this patent is valid invalid and this patent is infringed. You can't do it. You don't know what the claim construction is going to be until you make it to the Federal Circuit, right? You don't know where the prior art is out there. Patent law is inherently uncertain.
You have no idea what the damages base will be, the royalty rate will be, the injunction risk is going to be, what products are accused, what claims are asserted. If I can finish, the number one thing I hear from my clients, which are the general counsel and the chief patent officers of the biggest high-tech companies we have, and what I heard from the same people at a panel at the Federal Circuit Bar Association this year is the real issue with patent law, the thing that makes it out of control for American industry, is its complete unpredictability. So I just can't agree with you quite.
So there are degrees of unpredictability. I did not even need to open my mouth, and these guys knew I was going to disagree with them. Right? We have all learned the postmodern game, which is that stuff we say ain't perfectly clear. Yeah, okay, sure. That's true with every word, right? That any linguist will tell you that's true, right? We've all learned that in like Law 101. But there are huge differences between the kind of scope of liability question you have in a patent case and the scope of liability question you have in a securities fraud case. They're just really different. Now, I agree, there is no such thing as certainty. And I agree that my words are no more fundamentally clear than yours. But I do think that when you choose to be, you can be more clear than not. And when you choose to be, you can be less clear than not. And so can I. And so can all of us. And I think that the degrees of uncertainty and unpredictability, the nature is actually quite different in those areas of law.
But the uncertainty in patent litigation comes exactly from the words, because claim construction doesn't happen in some cases until 1 or 2 years down the line, is reversed 50% of the time. So people making business decisions, sometimes billions of dollars at risk, have no idea what this patent means until the Federal Circuit gets through it. And what it means could mean that their liability is $25 or $25 billion.
I don't mean to be heretical at a symposium sponsored by a Jesuit school, but I am not arguing the Thomas Aquinas view of meaning. I am not saying that the patent system uses words in ways that God herself will swear are fixed and certain. I'm just saying that the system is a little bit more certain than the new Sarbanes-Oxley restrictions we have in securities. I don't think that's actually a big claim.
Let's leave the debate over the relative uncertainty of congressional enactments at that point. Dan had a question.
I guess sort of a three-part question. First, I'd be very curious, although Tyler is supposed to be the moderator, I'd be very curious to hear Tyler weigh in on what copyright precedent tells us about voting. As you know, we have copyright cases that address this question. My recollection is typically the federal district courts say, yes, we could address your copyright claims from France or Japan or whatever, but we're, quote, not competent to do so, which means I don't want to learn Japanese or French or German copyright law. Which kind of leads me to the second observation, which is that the discussion was very interesting, but shockingly devoid of international law. And sort of, in some pushback to Scott, the default of international law is one of territoriality. And the reasons why Deep South came out the way that it did, not that Congress can't sometimes reach outside the country, but it certainly doesn't in copyright law, it doesn't in patent law. We do a little bit in trademark because it draws on, Lanham Act draws on the foreign commerce clause, but only a little bit. Antitrust is quite unusual out there, and they're commenting and international institutions. So it seems to me we need to think more about that. And then I guess the final comment is, with regard to most of the cases, it seems to me that we can't figure out what to do with ideas and information. That theme keeps coming up in these cases we've discussed. We've had one near miss in the past year, the Supreme Court saying, well, we'll think about correlation steps, but I guess maybe we won't. We'll save that for another day. But obviously they're concerned about this idea of patenting ideas, which, again, apologies to Scott, I think shows in these cases you're discussing, we're discovering just how nuts the State Street decision is.
Tyler, you want to start?
With regard to the copyright laws, you're absolutely right. Right, the few decisions that we have, the courts say that there's no jurisdictional barrier to hearing claims of foreign copyright infringement so long as we have personal jurisdiction over the defendant. But they do often use the forum non-conveniens, discretionary dismissal in order to allow those cases to be heard elsewhere, but not always, right? You've got a U.S. defendant, sometimes they'll hear those supplemental foreign claims in the United States. The Boozing Hawks versus a Disney case is a good example of that. But of course, with copyright, there's no problem with the active state doctrine, because outside the United States, there are no registration systems. I think the Philippines, but there are no registration systems for copyright, so there's no government action granting a copyright that would say the choice of forum should be in the courts of that government, right? Whereas with trademark registrations and with patent registrations, the active state doctrine has always been thought to require that validity decisions may be made in the courts of that state.
But so, just to follow up a little bit on this, right? I think it's absolutely right to say this is what the courts in copyright cases say they're doing, but it's also a bit what they're saying is a bit disingenuous, right? Because they invariably then go ahead and grant injunctions that prevent not just the sale in the United States, but sale anywhere in the world, right? And you see this in part on the internet where it's hard to sort of draw the lines, but it's U.S. courts regularly reach out and decide. Whether it's in the Computer Associates versus Altai case, right, where they apply a kind of worldwide injunction and damages standard, or whether it's the Grokster case, where notwithstanding the fact that the Netherlands had held the technology legal, the court says gotta shut it down altogether. So they are reaching extraterritorially, right? They're not doing it in a way in which they apply each law separately, right? Because I think there isn't the same sense of this is my French copyright and it is separate from my Belgian copyright that there is in patent law, right, where you actually do have physical government-granted rights that either exist in one country or don't.
I agree very much. Oh, sorry, go ahead.
Well, this is moving on, but I think all this pushes us to what's going to happen next. The last panel talked about what the USTR is doing in terms of pushing Canada towards enacting some extensive copyright laws, but I could easily see in the future the USTR pushing our regional neighbors to join a joint effort of having a joint body for issuing patents like the EPO does, as well as a joint effort that somehow allows for enforcement of those patents, which could eventually go into a worldwide patent system where either you have a patent or you don't have a patent, and either it's infringed or not, regardless of location.
So, and those are cool ideas, and I very much agree also with Dan's point that all of this has to get properly informed by understandings of international law, and we haven't done that here. So I don't think we claimed to, but I agree that those are important issues. My one real concern, though, is that as we internationalize stuff in the U.S., what we tend to do is turf it for negotiation purposes to the USTR. And we then end up getting a variety of agreements, international agreements, that are very detailed and represent a kind of consensus view of the people who are sitting down and talking to the USTR. Now, if you think that those people are experts and really good at figuring stuff out, you like that. If you think that in addition to being experts, they might, and this of course is where I come down, they might have somebody paying their way to participate in those conversations, they might be what we call lobbyists, then they're going to not do the mission of saying, gee, what makes sense? Instead, they're going to do the mission of, what do I need to bring home to my client to get what I need? And those kinds of decision-making processes, I think, are almost always going to favor the large established industrial players, and they're going to almost always disfavor competition, market access, little guys. And so if you want IP to be a regime that is out there helping little guys and being the regime that arms David with the slingshot he needs to attack Goliath, then you don't want all the detailed negotiations over IP, international or domestic, by the way, to be conducted behind closed doors in lobbying sessions. And I do think that we've seen that happen in the U.S. in our copyright system, and I do think we've seen that happen in the U.S. in our U.S. trade representative negotiations through TRIPS. And so my one caution is that we're actually, in a sense, handing over the system to the powerful lobbyists controlled by the powerful firms.
Okay, well, I'd love to continue the conversation, but we do need to leave it there. So first, let me ask you to join me in thanking our panelists.